So, um, Miss Galt, when we were at the Shell station in Battle Creek, are you aware that's a public place?
I'm aware.
Are you aware that you can videotape in a public place?
I am aware, but I asked you kindly to please stop.
Okay,
And
that's not the question. Are you aware it's a public place and you can video?
I'm aware.
Okay. So, if you were fearful and there's a video being taken, wouldn't that make you feel safer because it's on a video that somebody could actually review if they requested? If you felt unsafe, that would make you feel safer, correct?
No, it did not make me feel safer.
But it's on video. It's a recording, right? That would show the incidents that happened. There's 4 of them that I have. Is that correct? That you've asked me once to stop videoing, correct?
I was unsure if the situation would escalate, and it did make me feel fearful.
But how can you predict the future of what's going to happen? Can you read minds?
Objection, Your Honor. Argumentative.
Sustained. Just address the facts, sir.
Nothing further. Thank you.
Okay, thank you. Ms. McNiff, any other witnesses?
I have no further witnesses.
Okay. Mr. Schmidt, do you wish to testify?
Yes.
Okay. Raise your right hand, sir. We'll have you sworn in, and then we'll proceed.
Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes, ma'am.
Okay. What would you like to tell us, sir?
On August 22nd, August 29th, and August...
His need is a standard of living. Mr. Yost makes $55,000 a month. So it doesn't matter if my client needs $3,000 a month to live off of, or she needs $9,000 for extra expenses and a standard and a quality of life that she's accustomed to. That is still need. And that's what we're dealing with here. Again, there's been ample time for Mr. Thompson to respond to Dr. Quirin's report from January 17th that we provided to him. We are ready to proceed. This has been set on the court's calendar for a number of weeks. We need to get moving on this immediately. There's no reason to have a half day or a day long hearing over motions to modify a temporary order. It's not that complicated.
I'm sorry. And Your Honor, I'm astounded Mr. Olson made the argument that need is not a factor. Need is most certainly a determinative factor as to spousal support. And the court cannot make a decision when every, not just one or two, every expense is estimated. And it is not for the time of trial. She is asking for a change right now. So the need right now is what we need to determine, not what she may think she needs in a year or two, which I don't even know where she's coming up with these numbers, Your Honor. Most certainly $4,000 a month in attorney's fees for every month. But
may I at least inquire? My clients are, a bit of a hard spot financially, which is ridiculous considering the assets that these parties have available to them. One of the things that we've requested in our motion, one of them was that under the temporary order, there was a savings account through Credit Union of America, I believe, that had about $318,000 in it. And part of our temporary order had that account being split. Can we at least either address that, or the court would grant my client some advancement on property settlement, even if it's $20,000 or something like that, since we're going to be pushing this out till the end of April. I know I'm not trying to downplay $20,000 is a lot of money. It is not a lot of money for the assets involved in this case, and Mr. Yost is in control of all of them. So if there's some just temporary relief that my client can have, and again, I say that in the sense of advancement on property settlement, because if the court orders for her to be awarded an advancement on property settlement of $20,000, it's not that money just goes away and is forgotten. That would be a line item on a marital estate spreadsheet that she's already received that money prior to the court's final disposition or whatever agreement can be reached if ever it comes to that. So,
was there an incident that occurred on August 29th?
There was.
And can you tell me about that incident?
That incident was one where we were at a custody exchange and Ben was refusing to go. I calmly told Kyle that Ben was refusing to go and not wanting to speak to him. Kyle then proceeded to hit my windows of my car and continued to escalate and raise his voice. During this time, I was inching backwards to try to leave, And he continued to stay by my car. I inched backwards again, 1 to 2 inches. And he proceeded to start yelling that I hit him, even though I did not. And we made a statement to the police. They did an investigation, and I did not hit Kyle. So that was falsely.
What windows did he hit?
He was hitting my windows.
And where was your child located?
During this time, he was afraid. He was hiding in the back hatch of my car. He came forward to the front of the car, and he was cowering down between the seats because he was afraid.
When Mr. Schmidt was hitting your window, was he saying anything?
He was continuing to say that he needed to speak to Ben, to which I told him that Ben did not want to speak to him.
Did you roll your window down, or was it up?
I did roll my window down, so it was clearly heard.
And how far was your window down?
Maybe 2 to 3 inches, because he had reached in my vehicle prior to this, so I was not allowing my window to be rolled down more than that to put myself into a dangerous situation.
And how hard was he hitting the window?
Enough that it could audibly be heard in the car by my son, and it was hard enough that it was not lightly hitting my window. It was hard enough that it felt aggressive.
So it wasn't knocking?
No, it felt more aggressive than that.
Okay. And was there anything else with regard to that particular date that happened?
I was extremely fearful because I didn't know, with him hitting my window, what was going to happen next, and I was afraid.
And you said you made a report to the police. When did you make the report to the police with regard to that incident?
We drove directly down to the police station.
Okay. And you also indicated that there was an incident on September 5th?
There was.
And that was this year as well?
That was.
And what happened on the 5th?
On the 5th, I again tried to de-escalate, calmly say that Ben did not want to speak to him and was refusing to go to the visit. Again, Kyle continued to hit my window, aggressively. You could tell he was visibly mad, and I was trying to leave due to this. My son was again fearful. I was fearful. And once I rolled up my window, and he would not let me leave and was trapping me where I couldn't move my vehicle again.
How did he trap you so that you couldn't leave?
He was standing within inches of my car.
In front of it or in back of it?
Right beside me at my driver's side door.
Okay. And what resolved that you were able to leave?
I got on the phone with the police because I felt like there was no way that I could get out of there safely. When I got on the phone with the police, he charged back to my mother's vehicle. I was on the phone with them, and I could not see clearly what he was doing, but I later found out that he was telling my mom that he was going to go to her house.
Well, and let's not say anything.
In regards to me, though, he was still not allowing me to leave and entrapping me in my vehicle.
So when he went back to your mom's car, that allowed you to leave?
I was still on the phone with the police, yes, and assessing the situation.
Me saying I hit your vehicle and you said I'm backing up after I stated I hit you. If in the video you would say I didn't hit you if you didn't hit me, you just said I'm backing up.
I didn't hit you. It was investigated by police.
Do you recall a video ever seeing at the prosecutor's office?
It was investigated by police, and I did not hit you.
And the police indicated that you didn't intend to hit me, they stated, correct?
Your Honor, it's both hearsay and not a question.
Sustained. You can't say what somebody else said, sir. Only what the parties, either the petitioner or yourself said, but not other third parties.
Okay. So you stated on the 29th I kicked your vehicle. Do you have a footprint that's on your vehicle?
It was witnessed by Benjamin.
Okay, so you're here to testify today?
I am.
Okay, so you didn't witness it, you just assume that I kicked your vehicle?
It was witnessed by Benjamin.
Okay, well, he's not here today. Let's see.
To
So
hold on, to clarify, ma'am, so you didn't witness that.
I had my eye on my peripheral vision, and he was right there. But
Okay,
because
that's not what I asked. I asked, did you
No.
witness it? Okay, thank you.
No, sir.
okay, then you also stated on another date, I believe on the, let's see here, just going over my notes. On September 5th, you said I entrapped you. How did I entrap you in your vehicle when I was standing next to it?
Again, you were inches away from my vehicle, not making it safe for me to back up safely. In
But
which case, which is why I called the police.
Entrapment would be standing behind your vehicle, right? So that means it would be blocking you with a car, a physical person.
To be able to turn my wheel and safely back up, I was unable to safely back up. And because you were inches from my car, I was entrapped in the parking space.
No, that's not the definition of entrapment. On August 29th,
Sustained.
on August 29th, you had bumped your vehicle into my wrist. I have it on video, correct? I was videotaping on the 29th.
I'm unaware if you were or not.
I was holding my phone in your vision because I remember you seeing me, correct?
I saw your phone, but I wasn't aware of if you were videoing.
So when we see the video, will it show that I kicked your car in the video then? Will it show that I entrapped you on the 29th?
There was multiple questions. What was the question?
In the video on the 29th, will it show that I entrapped you?
Yes.
Will it show that I kicked your vehicle? Because you clearly said a second ago that you didn't see me. So would it show it in the video?
I haven't seen the video, so I'm
The
unaware.
prosecuting office has the video. You haven't reviewed it?
No.
Okay. Then you speak about August 9th that I had drove by your house. So you physically seen me drive by your house?
Due to you stating that there's a vehicle that is parked in my driveway, that would lead me to believe that you
what
have
road do you
driven
live
by
on?
my house.
What road do you live on? Beckley Avenue, correct?
Correct?
And that's a pretty busy road. There's lots of stores on that road, right?
Correct?
And from Galesburg to Battle Creek, that is a main route to get there, other than the highway when there's construction, correct?
Correct.
Okay, so you didn't visibly see me drive by your house then, correct?
My fishing buddy just won and lost in a custody hearing court battle that he's been dealing with for over 18 months with his ex-wife concerning his daughter. And right before his ex-wife was to lose and everything was going to go back to normal, she wasn't going to get extra child support, it was going to be evenly switched, she said she wanted a paternity test. After 11 years, he found out she knew all along that the girl that he has been paying for and loving, supporting, was not even his. And his ex-wife knew all along. I don't know about you, but I think she should be held. I think she should go to jail. That's what I think. And I also think, since there's no man in the picture, no father that she's ever known other than my friend, I think he should
enter a PPO that would restrict Mr. Schmidt from any stalking behaviors as are listed in item 5E of the petition, that he be prohibited from going to Ms. Galt's home, and that he be prohibited from interfering with or using any efforts to remove the children or any personal property from her premises. At this point, she is, and that of course he'd be prohibited from assaulting, attacking, beating, molesting, or wounding her. These parties have a long storied history of domestic violence and conflict, and these attempts at parenting time exchanges have escalated to the point where she is fearful, and Mr. Schmidt has been engaging in behavior that would cause her to be fearful for her safety, her physical safety, and we would simply ask that the court prohibit him from being able to continue to intimidate her.
Okay, thank you. Mr. Schmidt, any closing argument?
Yes. As far as she requesting stalking, I have never attempted or would want to stalk Mrs. Gall. I have never showed up at her residence in 5 years, she had stated. As far as removal of the children, I've only picked them up at exchanges, and that's it.
Okay, thank you.
You're welcome.
Well, in this case, the court has to look at the statute which is involved, and that's MCL 600.2950. And the court can enjoin and restrain certain conduct if the court determines there's reasonable cause to believe that an individual has committed or may commit the acts listed under MCL 600.2950 parens 1A through K. In this matter, first, it's been alleged she's fearful of him entering the premises. However, she did acknowledge in her testimony that he had not been to the premises for about 5 years, obviously, so there's no fear of entering upon the premises. She's fearful of the videotaping, but the point that Mr. Schmidt makes is appropriate, that if he's videoing it, then she should feel safer, not feel unsafe or fearful because of the fact that it's all videoed and all records. So the court doesn't, again, believe that that's appropriate under sub K, where she might, in fact, cause reasonable apprehension of violence because somebody is videoing her. She may not like it, but that doesn't mean that there's going to be any, again, violence as a result of that. In fact, the court would believe, as did Mr. Schmidt, that it'd be less likely to be any particular violence. She claims he hit the window. He claimed I was tapping on a window to get her attention. The court has, through the ex parte order the court entered, has taken care of that by keeping him 20 feet from the car when the exchanges occur in this particular case. The court notes that the other objection, nope, you guys are done. It's my turn now, Mr. Schmidt.
Okay.
The court does note that she states she hasn't seen him. She's never seen him go by the house, so she can't claim that he was engaged in stalking behavior. He did raise the point, maybe somebody related to him that they saw a vehicle at her house. That doesn't denote that he, again, was engaged in any behavior which would be stalking under the applicable statute. The court in this matter does believe that the court's taking care of the issues that would be germane in this matter about being next to her vehicle, and believes that that is taking care of the matter. I don't believe that it's appropriate nor necessary to enter a PPO. I will deny the petition for entry of PPO at this time. So you're free to go today and have a good day. And we will be in, obviously we'll have.
Request being made by the plaintiff is that I order the kids not to refer to their new stepmom as either mom or mama. That's in effect what you've asked. So just so I understand, you want me to order the kids not to do that, and then if they do it, you want me to hold them in contempt and maybe fine them or lock the kids up for doing it? Is that what you want, ma'am?
No, I just was requesting this because I feel it blurs the boundaries, and I feel...
Well, I'm saying, you want me to order the kids not to do that?
No, I just wanted it to be ordered for her not to be called that because they are...
It's the kids who call her. It's the kids who say it. So if the kids call her that, what do you want me to do?
I understand, but they are telling the kids to call her that, and they're confused by it. So I just feel like it's inappropriate.
They have two moms. They have a mom and they have a stepmom right now, and I'm not going to get into what is appropriate in there. I mean, it's micromanaging. Let the kids be kids. They're only 6, 5, and 2, aren't they?
Yes, Your Honor.
Yeah.
It doesn't sound like you're very have much self thought about. You're afraid the kids are going to see her as the mom or something like that. The kids are growing up. They'll know you're the mom. I'm not going to tell them, as long as they don't call somebody derogatory names, I don't care what they do. Because I'm not going to hold the kids in contempt for calling her that.
Right. I understand that.
All right. So I'm going to deny that motion. You got one here that you want to exchange some about the holidays because you got week on, week off. Well, I'm not going to be modifying an order. You mean you don't want to exchange for Christmas or whatever else is in here according to the holiday schedule. Is that what you're asking for?
Yes, Your Honor. Ryan and I agreed just to keep the schedule the same, just week on, week off, and not go back and forth during the holidays.
Okay, so I guess I don't need to do anything because you guys agreed to it. You guys can do whatever. You guys can do whatever you want on holidays. You need a court order saying what? Eliminate all holidays in the schedule?
No, Your Honor, I do not want that. I want that to reflect because unfortunately, she goes back and forth. So I would like to keep at least that effective, and then we can do our own thing if we choose to.
You guys can always do your own thing if you can agree to it. But other than that, the court order has what is going to happen in there. So if it has violated somebody, if he violates it and doesn't give you the kids on Memorial Day because it's your Memorial Day, but it's his week, and holidays always trump regular parenting time for both of you. So we'll keep that in there. If you can work stuff out, you can work stuff out. Third request is child.
So you stated on the 29th I kicked your vehicle. Do you have a footprint that's on your vehicle?
It was witnessed by Benjamin.
Okay, so you're here to testify today?
I am.
Okay, so you didn't witness it. You just assume that I kicked your vehicle?
It was witnessed by Benjamin.
Rachel Galt versus Kyle Schmidt. It is Monday, September 30th, 2024 at 12:09 p.m.
Court will note the appearance of Ms. McNiff on behalf of the petitioner in this matter and the defendant representing himself. Is that correct, sir? You're going to be representing yourself?
Yes.
Okay. Ms. McNiff, do you wish to make an opening statement in this matter or proceed to proofs?
We'll proceed to proofs, Your Honor.
Okay. Sir, you can make an opening statement or you can reserve on the opening statement or waive your opening statement. What do you wish to do?
I'll reserve it.
Okay, thank you. Ms. McNiff, call your first witness.
Ms. Galt.
Okay, Ms. Galt, we have you raise your right hand, be sworn in, and then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Okay, go ahead, Ms. McNiff.
Thank you, Your Honor. Ms. Galt, you filed a petition for a personal protection order against Mr. Schmidt.
I did.
And can you tell me what happened on August 9th between you and Mr. Schmidt?
August 9th, there was an incident that took place that Kyle was hitting my vehicle, yelling at me, trying to ask to speak to Ben, which I told.
On August 9th, or did that involve a message on Our Family Wizard?
Oh, I'm sorry. That was the wrong incident. I apologize. Yes, there was a message sent to me by Kyle Schmidt on Our Family Wizard about saying he needed to know the full names of everyone parked in my driveway. And he also needed to know who was driving the white vehicle in my car.
And why did that concern you?
It made me known that he is watching my house. And because there is a white vehicle that is in my driveway that is a family member's, but hadn't been there for at least a week prior to that. So
do you know where Mr. Schmidt lives?
In Galesburg.
And do you have any reason, was there any reason for him to be at your home?
No.
And is your home located on a major thoroughfare?
It's located on a crossroad, yeah, a road that is used for traffic.
And when was the last time, if any, that Mr. Schmidt was at your home for a sanctioned reason?
It's been at least 5 years.
Half of a lottery winning in the amount of $20 million. Is that correct?
Yes, correct.
Okay. Explain to me why you are entitled to have winnings.
So I'm seeking this money because I strongly believe it still goes under marital property. Since he got this ticket using our shared account, and then that he got it before our divorce papers were finalized. And I supported this man for 7 years, following him everywhere he goes so he can chase his dreams. And I give up on my career and my life to support him. So I think, again, I'm here to seek a fair distribution. I'm not here for greediness.
And you said he reversed ticket prior to. When was your divorce finalized?
rented October 7 on 9 a.m. at 9 a.m. I believe.
Okay, good. All right.
Thank you, Mr. Taylor.
Thank you, Your Honor. Well, one thing is true. We were divorced on October 7th. That is the one true thing that she has communicated to you. The full truth is that we got divorced that morning, and then, as you can see from the receipt, later that day, after I had lunch with my attorney, I left his office from the finalized divorce, and I stopped on my way home to pick up some beer. I bought a six-pack. I was going to go home, watch the game, just kind of relax a little bit. And on a whim, as I was paying, I decided to buy a lottery ticket. And so I bought a lottery ticket, something I almost never do. And that's when I won the money. So it was clearly after the divorce. She has no claim on that money. And this is really a waste of all of our time.
So you allege you bought the ticket after the divorce was finalized.
Absolutely, Your Honor.
Okay. And Ms. Taylor, you said your divorce was finalized at 9 a.m. that morning?
Yes, correct.
Okay. Well, you did submit a receipt?
Yes, Your Honor. I submitted a receipt from when I purchased the six-pack of beer and the lottery ticket. And you can see clearly it was at 12:30 in the afternoon.
If you allow me, I can also add to that. I strongly believe those numbers you see on the lottery tickets is not coincidence. It's our mutual history. And without me, without us, he will not have won it. I can explain you more if you allow me. So those numbers are 2, 7, 14, 21, 28, and 39. So 2, December 2nd, the day we got married. June 7, the day he proposed. August 14, our wedding anniversary. 21, May 21, our dog's birthday. 28, February 28, our first romantic date. And 39, believe me or not, 39 cities we changed chasing his dreams to become an actor or, I don't know, a travel blogger. So I give up like everything for him, give up my career, and I supported him for 7 years. I think I deserve that money, and it's fair.
If I may, Your Honor, she's trying to find significance in these numbers, but the truth is I did a quick pick. I didn't even pick the numbers. The computer picked them for me. I have no idea if all those dates are even correct. I think she's making this up. And if, again, I may, Your Honor, I think some context here. And if I may, Your Honor, obviously you can see there's a pretty significant age difference between us. I flattered myself when we got together that she found me attractive for me, but as we lived together, I learned that she was really just interested in what little money I had, which was probably a lot less than she thought I had. She never had a job the whole time we were together, and when most of my savings was gone, that's when she filed for divorce from me. So this career thing, I don't know where that's coming from.
What savings are you talking about? Like, I spent everything on groceries, barely affording it, okay?
Ms. Taylor, so you were with Mr. Taylor out of love, and then sounds like he ran out of funding.
After 7 years.
After
not
7
like
years?
1 month or something. 7 years, it's a big number. I wasted 7 years of my life, best time of my life, on this gentleman. For what? He throwing me away like a, I don't know, homeless cat or something.
Matter.
I mean, he also make us so much pressure to divorce. I mean, I thought like he never did something similar in that entire life, like throwing away garbage or fixing broken coffee machine or something. And all of a sudden, he becoming like, I don't know, Usain Bolt or how do you call it, Flash. Forcing me to divorce as soon as possible. I assume he bought this ticket before our divorce was finalized.
Your Honor, you can see from the receipt that I did not buy that ticket before the divorce. She was the one that asked for the divorce from me. I didn't rush things through. It was a pretty simple divorce. We don't have children. There obviously wasn't a
We
lot
have
of
our
money.
dog, though.
We do have a dog, yes.
Okay.
But that was a pretty easy. So the divorce just went through quickly because there was nothing to stop it after she asked for the divorce.
Well, Miss Taylor, you're the one who filed for divorce, so I can't.
But he rushed it to no end.
You're the one who
Without
filed for
making it
divorce.
fair. I'm here for fairness, not greed.
Now, I do understand how you can feel hurt and upset because your now ex-husband has come into quite a bit of money. And with that, unfortunately, all of it belongs to him because, as you stated, your divorce was finalized.
But it's not fair.
At
It's not
9
7
a.m.
years to the garbage.
You should have hung in there till 12 o'clock that afternoon. So,
It's
what
unbearable.
unfortunately
He
you did.
promised me like fake things.
I do understand, and I am sorry you wasted the best years of your life, as you state. But the law is the law, and no matter how much sympathy I have for you, I can't rule any other way. Now, from what I understand, Mr. Taylor, you have a countersuit here for $2,500?
Yes, Your Honor, that is correct.
Okay.
Yes, that's to cover my own personal expenses, consulting with an attorney, the ridiculousness of this situation. So I just wanted to file a countersuit to sort of, draw more attention to the absurdity of this situation and for all of us having to be here and waste our time.
Mr. Taylor.
Yes, Your Honor.
25, and you just won $40 million.
Your Honor,
peanuts for him.
You are correct, and it was more of a gesture to. I'm not concerned about that money. It was more of a statement of this is ridiculous, and if you want to.
Sounded like a statement of revenge to me. Now, look here. That, as for your common claim, I'm gonna throw that out because that's just ridiculous. Now, what I can tell you is, once again, I am sorry that I can't assist you with this one, Miss Taylor. As much as I would like to, from woman to woman, it'd be nice, but I can't. The law is the law, Mr. Taylor. There will be no countersuit for you. I do understand you probably want to get back at her a little bit, but I'm not going to be a part of that. Okay?
I understand, Your Honor. Thank you.
All righty. Case dismissed.
It's not fair,
Congratulations. Thanks. I am incredibly relieved and grateful to Judge Monroe for her wise decision. She was very fair, and I'm very grateful that she's done the right thing. And I'm going to go and enjoy my life a little bit more with someone maybe a little closer to my own age.
I'm not satisfied with the decision, to say the least. After 7 years supporting my husband and being on his side all those times, he could just give me like $500,000 or something. Asking me to pay $2,500 is just ridiculous. After him getting $40 million, it's peanuts.